SJC-12390 in the matter of a guardianship.
Mr. Boyne, good morning.
Good morning, Chief Justice. Good morning, Associate Justices. Good morning, Your Honors. May it please the Court, Michael Boyne. I'm here with my associate, Attorney Jessica Dorazzian, and we represent the hospital in this matter. Your Honors, the case before the Court stems from a contested guardianship petition out of the Norfolk Probate and Family Court. After contested hearing, a judge determined
Could you
that...
get a little closer to the microphone?
Certainly. After contested hearing, a judge determined that the patient in question didn't meet the criteria to be an incapacitated person by the statute, but then allowed the hospital's request for authority to transfer the patient to a nursing home, which I would suggest is contrary to the way guardianship law is structured in the state at this time, leaving no competent decision maker to effectuate that transfer.
The statute in question, does it have a requirement that the person be considered incompetent or diagnosed, or just does it require an impairment of communication?
Well, Chapter 190B and the UPC together explain that incapacity requires, it's MGL 190B 5-101 of the UPC holds that an individual who for reasons other than advanced age or minority has a clinically diagnosed condition that results in an inability to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements of physical health, safety, or self-care, even with the proper technological assistance. Case law has also determined that to have an appointment of a guardian, you have to have a determination of an incapacitated person. And whereas the judge didn't appoint a guardian in this case, he then allowed the hospital's request for authority to transfer to a nursing home, essentially making it an untenable situation for the hospital to manage.
The hospital, I mean, as I read the questions the judge reported, he's saying that finding of mental incapacity had to be determined first. And do you agree with that? That it has to be mental, not just an incapacity affecting communication?
I do. I agree. For a guardian to be appointed, it has to be a mental incapacity.
Mental incapacity. So in this case, when he made his findings, he made findings regarding communication, patient's ability to understand her own medical condition.
He did.
But nevertheless made a conclusion that for purposes of the transfer, she needed a guardian. But are there any facts in there that support, would explain, you're probably the wrong person to ask, but why?
Well, I don't know that he necessarily, maybe it's a semantical thing, I don't know that he necessarily said she needed a guardian. I think he specifically said that she didn't need a guardian and that she didn't satisfy the incapacitated person prong of the statute. And I would suggest if that was his ruling, he should have stopped there and not gone on to then allow the hospital the authority to transfer the patient to a nursing home. In this particular case, Your Honors, the patient, as the facts lay out, the patient had been at the hospital for, I believe, 108 days at this point.
Right.
She was refusing all care. She required a hip replacement surgery that she was going back and forth on whether she would have. She had signed authorizations, then she would, for no reason at all, determine that she wasn't going to have it. She first presented to the hospital in January of 2016, post-fall.
Doesn't he then changes his mind, right? Now he's imposed a guardianship. Isn't this whole thing moot and also basically a product of an original error? And I'm just not sure what we're doing here. If he got it wrong the first time, and he finally figured it out, all these issues are sort of academic, aren't they?
I agree to a point. I would suggest that although the issues are academic, and I agree that the guardianship in this particular matter is moot.
And not only are they're idiosyncratic and odd and a product of sort of the first decision, right? I mean, if the first decision was she needed a guardian, then they could move her to the nursing home, right?
If he had appointed a guardian, they could have moved her to a nursing home.
If she were incompetent, he could have appointed a guardian, moved to the... I find that we're sort of answering a lot of abstract questions that may have just been a product of an erroneous first decision.
Well, I would say as far as the second decision goes, I did that. I wasn't involved in the first decision, but I did do the second trial, and I would suggest that at that trial, the judge did limit the evidence from his prior decision.
When you talk about the second, you're talking about the one that's not in front of us right now.
That's correct.
So not the second part of this judge's decision, which is to award the guardianship.
That's correct. Same judge, same court.
Right.
But he limited the facts.
Same proceeding.
Same proceeding, well, different attorneys, but essentially the same proceeding. The committee was represented not by the same attorney that represented the patient in the first hearing, and I represented the hospital, and I didn't represent the hospital in the first hearing. But he did, in just speaking to that, he did limit the evidence at that time from the original decision to the time of the new trial. So our original decision came down, say, in November of 2016, and then the new trial proceeded in October of 2017. So the information that came in at the first trial, some of it came in because it was repetitive, but for the most part it was limited. Back to Justice Kafker's question as far as is it academic or not, is it moot? I would suggest that I agree that it's likely moot as to how it applies to this particular patient, but I would suggest that since the UPC changed, there's a very low amount of case law that applies to guardianship law at this time, and it seems to be applied differently in different probate courts. So I think guidance could be helpful.
This
even
issue, though, I mean, the questions that were sent seem idiosyncratic. I understand that there's not enough guidance on the new law, but we're being asked to answer some slightly odd questions. Are those likely to come up? Or are those really going to be decided in whether someone needs a guardian or not?
I mean, is it likely to come up? It's hard to say, Your Honor. I could tell you I've been doing guardianship law for quite some time now, and I've never encountered a decision like this. In our research that we did, we never found any case law that would be on point to this type of decision. But I do suggest that it's capable of repetition and potentially evades review, because I would suggest that most hospitals, every time a decision like this is going to come down, and this is a split the baby decision for the most part. I think the judge had good intentions. I think what he wanted to do was give a decision that included everybody and was inclusive and helpful to everybody. But in reality, what he did is he certified this patient not suitable to discharge to the community in our mind. So if the hospital were to discharge her and then something were to happen to her, we'd be in the position of facing liability. They would say, why did you discharge this patient when the judge just certified that she was...
But what is there about this case that would solve the serious problem of somebody who may have difficult issues, but ultimately is competent and isn't going anywhere?
Well, just as far as this case, I would suggest that the judge also made a clearly erroneous error in finding the patient to be competent. Is this case going to solve... I agree that this case may not solve future cases that come down, but I would go back to what I was saying to Justice Kafker, that with the lack of current guardianship law that applies to these cases since the UPC, I think certainly some guidance would go a long way on all the issues.
So help us out, because you can't reconcile both decisions, right?
Correct.
And so how is anything that we would address going to address the underlying financial issue, moral issue, and legal issue when you have somebody who's in the hospital who might have all sorts of difficulties, confusion, views about medical care, but they're competent, maybe highly functioning, and they're not going anywhere? I may be wrong. It seems to me beyond this case.
That wasn't, I would say that those facts weren't the facts of this case. I guess you're asking me going forward, how would it help?
Something we do in this case, going back to Justice Kafker's, I'm going to his question in a different way. What are we supposed to do here?
Well, I suggest that the court would have the authority and the ability to expand the definition of an incapacitated person and provide that guidance to the lower courts.
So would that expansion be to include something beyond mentally incapacitated?
It could be, Your Honor, because in this, what do you do with a patient who's, I know my sister made a great point in her brief of bringing up spinal cord injury patients. And I mean, if the patient is not going along with the discharge plan, but there's nowhere else for the patient to go, then I would suggest that that's a loophole in the law right now, that there's nothing that the hospital can do for a patient. If I'm a spinal cord victim and I'm laying in a hospital bed and I refuse to participate in all the treatment planning and I want to be discharged back to my second floor apartment, I don't see how you can expect a hospital to be able to facilitate that safely for the patient. And there has to be a mechanism then to get that patient to the next step of whether it be intermediate care, long-term care, a short-term stay at a rehabilitation
But
center.
I'm confused by that. So you have a perfectly competent person, loves your hospital, doesn't want to leave. You can't say, we need your bed, you got to get out of here?
Well, I guess you could say that, and I think the hospital in this particular case, they tried multiple times to talk this patient into different various discharge plans.
You have no, I mean, as a matter of law, you have no ability to remove, say to a competent person, you have to leave the hospital? I'm surprised to hear that. That may be true, but.
Well, I would suggest, how would we practically do that? I mean, are we going to trespass the 79-year-old patient that's not mobile and bedridden? So it just puts the hospital, the bottom line, Your Honor, is when the hospital discharges this patient to the community, whatever happens to that patient, the hospital is going to own it in the future. If you discharge a patient to an unsafe condition.
So is that the issue you're asking us to decide, whether when someone refuses to leave the hospital and they're competent, but we want authority to do, because it didn't sound like you want us to approve what that judge did.
No, I on this particular case, I would ask you to find that the judge erred in finding clearly erroneously that the patient did not satisfy the statute and was an incapacitated person.
So you don't want us to answer that question, whether you don't want us to give you that right.
Well, I would take, obviously, anything that the court is willing to answer. If the court sees routes that I haven't addressed, then certainly I would ask the court to
Say
intervene.
in general that in most cases where somebody is going to find somebody is not able to participate in their discharge planning, that the judge would most likely usually also find that they are mentally incapacitated.
Yes,
For general purposes and not just for a limited guardianship.
that's been my experience. And I would
Does that
suggest,
mean that we are trying to figure out a solution to a situation that isn't a problem?
on the majority of the time, it's not a problem.
How about in the overwhelm, I don't know. I'm just wondering if we're trying to find a solution to an issue that's not a problem. Is it in the overwhelming majority of the time not a problem?
I think it's a majority of the time this wouldn't be an issue. This was a unique decision, I believe. Like I said, I've never seen a decision like this before. I think it was partially the court, like I said earlier, was trying to come up with a decision that satisfied everyone. And oftentimes, as through your experiences, I probably expect that you know that that's usually a difficult task. So it's not something that comes up in the majority of the cases. But when it does come up in a situation like this, it creates an unmanageable situation. I would suggest both from the institution's perspective and from the patient's perspective. This patient sat on a medical unit in a hospital for like I said earlier, 108 days. It exceeded that, but at that time it was 108 days.
And costing, I assume, costing the public? Or?
Yeah, I would. Well, I don't know. I mean, I don't know what kind of insurance situation it was. If it was a Mass Health situation, I would certainly suggest that Mass Health would have stopped paying quite some time ago.
Well, but I mean, so then the hospital bears,
Yeah.
I mean, isn't that sort of it appears, as to this case reflects the problem, that the judge, in order to get this person out of your hospital, the judge is pushed to make a finding that may not be warranted by the evidence.
Well,
I guess if the judge finds she's not incapacitated, then you don't have the authority to say you should not be here, you should be at a nursing home, or you should be a nursing facility.
Right. That would be up to the patient at that point.
So isn't that sort of a problem here, is that the judge then says, well, I need to now find the person to be incapacitated. The person doesn't actually fit the definition, but we have a problem that the law does not. The only way that the law addresses this, the way to solve that problem is to make a finding that I, in good faith, should not make, which is that the person fits the as a clinically diagnosed condition that results in inability to receive and evaluate information.
If I could respond to that, Your Honor, I think that's a great point, but what I would say is I think the law does address this because the law accounts for the appointment of a limited guardian for a limited scope of purposes. The law says that you could be incompetent for all purposes, or you could be incompetent just, or incapacitated, I should say, just for specific purposes.
What was missing in this order was a finding that although the patient was competent for her own medical decisions in general in terms of whether to have surgery, she was not competent based on a mental illness to decide whether a discharge to a nursing home was appropriate.
I 100%
Is that the
agree.
finding you would make?
Yes, I 100% agree with that
And-
statement, and I would suggest, I'm sorry, Your Honor.
No, give her.
I would suggest that by finding the patient, and we suggested this in our brief, but by finding the patient not able to participate, and that's essentially what the judge did. He found that he essentially found her to be competent, and then he found her not able to participate in her own discharge planning. I suggest that's the very definition of somebody who needs a limited guardianship. So at a minimum, I believe he should have found that she required a limited
Also
guardian.
was critical of the medical certificate, wasn't he? But I'm not sure. Are you making any argument that he was overly critical there?
No, I don't think he was overly critical of the medical certificate. I think the medical certificate had a lot of factors in it that I think were positive to the court. But I do think on review that it was lacking in a diagnosis. I think that was addressed at trial by Dr. Brown for the hospital when she opined her diagnosis and she relied on her personal observations and the content of the medical certificate.
Just to sum it all up, what are you looking for?
At a maximum, I would be asking the court to find that the judge did err and clearly erroneously finding that the patient didn't satisfy the incapacitated person statute and that a full guardianship should have been appointed at trial. At a minimum,
Full guardianship or limited guardianship?
my personal view is that the patient did satisfy the incapacitated person prong of the statute. So I would suggest it should have been a full guardianship. But at a minimum, I would suggest that the court should have found that the patient required a limited guardian to be put in place for the purpose of planning discharge and making discharge decisions with regard to nursing home facility or intermediate care or whatever would come next.
And then with regard to the questions that have been addressed to us, how would you say we need to answer them?
So those questions, I feel the questions are very interrelated. The judge's questions were, can he essentially, I believe the first question was, can he essentially find someone to, can he order somebody to a nursing home if they're not to be an incapacitated person? I would suggest under the current law, he's not able to do that. I think all the questions are interrelated. I think he needs to have a finding of incapacitated person before he can order someone to go anywhere based on the current law. That's why maybe another thing that the court could address would be expanding the definition of a limited guardian so that a situation like this doesn't fall into blind spots.
And is that by statute or is that by common law?
Well, it's determined now by statute, but as I said, there's no guiding case law, none at least that I was able to find prior to coming here today.
Now, the statute refers to those who are incapacitated for reasons other than advanced age.
Correct.
If somebody has some degree of dementia, then what happens?
Well, that's another great question, Your Honor, and I would suggest maybe we're parsing words by saying advanced age and dementia. I mean, people of all ages, there's early dementia. People of all ages could have dementia. I've spoken with doctors that consider dementia to be a mental illness. So I think that you could have found that this patient needed the guardian regardless of the fact of what her age is. And dementia, as I said, is not isolated. I know it's obviously more common in the elder population, but when I go on these units, and I do, it's essentially my job, I see patients of all ages on sometimes geriatric units, I think start as young as 55.
Okay, so I'm trying to sort of sort this out. So you mentioned the person who was paralyzed or whatever. Mm-hmm. Let's take the more common situation of an elderly person suffering some degree of dementia who says, I don't want to go to a nursing home, I'm very comfortable here, and you say, no, you should be in a nursing home, or you should be in a nursing care. You broke a hip.
Right.
She broke a hip. She's in the hospital. She still is in some degree of pain. She thinks I'm going to get better care in the hospital than I would in a nursing facility. Not crazy. And having some degree of dementia. So
What I would suggest, though, Your Honor, is that the patient no longer reaches a hospital level of care at that point, and they're suitable for discharge to a lower level of care, i.e. the nursing home or
And
i.e.
she says, "Thank you, but I'm perfectly comfortable here."
Well, and that creates an untenable situation, but
But, I mean, my question is, do we say that's untenable, or do we attempt in this opinion to make it tenable?
I think we should attempt in this opinion to make it tenable, Your Honor.
And how do we?
I think the tools
and
are
what
there.
do we do? What do we do to make it tenable?
I think we can either, well, like I said earlier, personally, I think that this case could have been solved under current law.
I'm referring to a different case. I'm referring to a broken hip of an elderly woman with some degree of dementia, but not necessarily one that would say that your dementia has reached the point that you're incapacitated.
I would suggest that this court has the authority to expand the definition of what's required to appoint a limited guardian in that situation. I think if a judge finds someone not even able to plan for their own particular discharge and living situation,
was it
then
really
that in
that-
and of itself, I'm sorry, Your Honor, is incapacity.
Yeah, no, it seems like the finding really was that she didn't want to plan, not that she was unable to.
Well, that may have been the finding, but I think the facts are very contrary to that. She didn't participate in any of the evaluations. She would never ask questions that were logical to her situation. Like I said, I believe the judge made a clearly erroneous error on the finding.
So under the new probate law, the new guardianship law, how would you like us to write this? That this provision allows you to impose a limited guardianship for someone who's got mild dementia but likes the hospital? I'm just trying to understand because that's sort of what the judge did, but you didn't like that. And I understand that she may have been more extreme, but...
Well, it's not that we didn't like it. It's just that there's nobody on the other end that's going to accept a patient
And
when
you're
there's
sure
no
there's-
competent decision maker to sign them in, and the patient herself wouldn't sign
And
herself
hospitals don't have powers to say it's time to leave? I understand they may be exposed to some, practical problems, but I'm surprised the hospital can't say, you're not appropriate for us. It's time for you to go.
I'm
it's
not saying-
something you lack.
I'm not saying that the hospital can't say that. What I'm saying is in this particular case, we have a 79-year-old person with a fractured hip who's immobile. So how do you, with no support systems, no family behind her, so do you wheel her out outside the hospital? How do you do that?
But I'm worried that we're taking the guardianship law, and as the chief points out, we're forcing the guardianship law into this contorted position when there are other vehicles. I don't know them and we haven't briefed them, but I'm surprised that hospitals don't have legal authority to terminate these services to a competent person, even one with mild dementia. But maybe you do this for a living, so I know this is complicated, but I just worry that we're in the wrong statute.
I just don't think it's as simple as Your Honor is stating.
I'm not saying it's simple, believe me. I understand it. It's practically a big problem. I just don't know that we're focusing on, we've only briefed one legal component of the law of hospitals and patients, and I'm just wondering whether we're trying to manipulate this one into a way that there's some other thing that's more designed for this. But
That's actually my issue, too, that I'm trying to figure out. So I'm sure Justice Kafka's right. If you have some patient who's paralyzed or has ALS and they don't have family and you want to move them out, you can. But
Correct.
you're not going to put them on Main Street in Worcester and leave them there. You're not going to do it because it's immoral and it would be a mistake as far as possible liability.
Correct.
And what I'm trying to figure out, I think maybe we're all getting at the same thing. Is this case some vehicle to try and solve this? And I guess the preliminary question is this a problem that needs to be solved?
I think certainly this case could be a vehicle to try to solve this. Is it a problem that needs to be solved? As I said, it's not a problem that I've seen normally with the fact pattern like this. I would suggest that a majority of the judges that I practice in front of in the probate court who find that this particular patient was unable to plan for their own discharge by taking that right away from them and ordering the hospital to be allowed to transfer them to a nursing home would have also found them to be requiring at least a limited guardian, potentially a full guardianship.
But the Chief Justice Gantz's concern is something that we have to recognize. We don't want probate and family court judges, torturing the facts because the law doesn't make sense.
And that's, I don't think anybody would want that, but you, in your statement, Justice Lowy, you said with family. In this particular situation, there is no family, so there's nobody for us to come to. There's no dutiful son, there's no husband for us to go to and say, listen, we really need to get your loved one out of the hospital, we need your assistance to do this, this is what we'd like to set up. We didn't have that here. What we had was a patient who has, I believe, one estranged daughter on the other side, in California, I believe it was. So there was practically there was nothing for the hospital to do to get her out other than try to trespass her from the premises, which we're not in the business of doing that, Your Honor.
All right, thank you.
Thank you, Your Honor, for the opportunity. Appreciate the time.
Ms. Talley?
Good morning. May it please the court, Karen Talley on behalf of D.C. Unfortunately, the issue of mootness was not briefed because we were not made aware of the subsequent proceeding. But
this was your client, wasn't it?
yes, and that was, if I can go beyond the record, that was the only way that I found out that the client was when the client contacted me. I was not told by either the court or by counsel for the hospital that there was a subsequent proceeding. And unfortunately, that was after after the briefs had already been submitted. So, but I do just want to touch on the issue of mootness briefly, because it is a matter of first impression, and the definition of incapacitated person is the most core element, the most core definition at the heart of the guardianship statute. I think we would all agree that matters of guardianship, matters of mental health law have been determined to be matters of public importance. It's unclear why in the 8.5 years since the MUPC was passed, there hasn't been a decision before this court about the interpretation and application of incapacitated person. It could be that, as in this case, if petitioners aren't successful in meeting their burden, they wait a period of time, they get another order, and it's mooted out. So in that way, it is capable potentially of repetition yet evading review. This issue has been fully briefed, and so I would urge the court to exercise its discretion.
Do you agree that incapacitated person, the statute requires that it be because of mental illness?
A clinically diagnosed condition, yes. If
Mental illness, clinically diagnosed.
Yes, I think that can include dementia. If you're distinguishing it from physical, the type of physical mobility impairments that this client has, then yes, certainly. I don't think it's limited to mental illness strictly, because it could be somebody who has a neurological deficit that prevents them from communicating.
Right, but it says incapable of taking care of themselves by reason of mental illness.
That's the definition under the old statute.
So how does the new one change it?
So the new one changes it, and I'm glad you brought that up, because Petitioner Hospital, in their brief, seemed to imply that the changes from Chapter 201, Section 6 to the MUPC are mostly procedural, and I would argue that they are substantive. The definition that you just cited, incapable of taking care of himself by reason of mental illness, is the prior definition. It's 11 words. I would submit that they're 11 very vague words. In contrast, the MUPC, which was passed in 2009 for the explicit purpose, legislative intent, as this court found in BVG, of reducing the number of unnecessary guardianships or unnecessary plenary guardianships, has a 45-word definition for incapacitated person, a clinically diagnosed condition that results in an inability to receive and evaluate information or make and communicate decisions to such an extent that the individual lacks the ability to meet the essential requirements for physical health, safety, and self-care, even with appropriate technological assistance.
So in this instance, even though it may be moot, the judge found she was not, do you think the judge was just applying the wrong standard?
No, I think the judge correctly applied a very precise standard and applied it in the way that the legislature intended. He took very seriously the definition of clinically diagnosed condition. It's not clear whether he found that or not, but even conceding for the sake of the argument, if he did find her to have a clinically diagnosed condition, his primary finding was that she didn't have the inability to receive and evaluate information.
Well, but he also, it's unclear to me from the questions that he reported whether whether he thought she was mentally incapacitated.
No, I think with all due respect to hospital counsel who's asserted that the judge made a finding that she was unable to plan for her discharge, there is no such finding. I can point to, and they point to, no finding in the judge's findings that said she was unable to plan for her own discharge. He clearly found her not to be an incapacitated person under the very precise definition in the statute. He applied that very precisely.
Then he later found her to be that, right?
In the subsequent proceeding.
So
which
you're
we were
saying, put
unaware of.
aside what happened later, you're saying the judge erred by basically saying that she should be transferred.
Correct. Well, I don't think the judge erred because I think his solution was to report up these questions. I think the judge himself in the motion hearing, the transcript from the motion hearing, and in the reported questions, when you take those two things together, he is properly, I think, questioning his ability to enter any orders once he found her not to be an incapacitated person. I think he's correct in that. I think there's no such finding that he somehow found her on a limited basis.
And again, it has to be a mental incapacitation.
Well, again, I think there are conditions where if you look at that, a clinically diagnosed condition that results in somebody's inability to communicate, that could be a physical or a neurological condition.
So which of the hospital, so tell us, okay, this is an untenable situation. She won't leave. She's not abiding by any of their directions. A normal person they'd ask to leave. What's the solution to this? I mean, because the solution isn't she gets to, on the taxpayer's dime, stay there forever when she doesn't belong there, right?
Correct.
Because she won't cooperate.
Correct.
So what's the appropriate thing?
So, as I noted in the brief, I think what's being posited by the hospital's position is a false dichotomy. I think that there is something in between allowing her to stay, getting, none of the treatment that she says she wants that is.
You be the
is
judge.
needed.
Tell us what should the order have been from the judge in this situation, besides ask the SJC? What should the order be?
I don't think that the judge, once he has found her not to be an incapacitated person, has the ability to enter any further orders.
Okay,
Whether
so-
he admonishes the hospital to take some of the other routes that we suggested in our brief, whether to seek mediation, not under the jurisdiction of the court, but to seek mediation, to arrange for the second opinion that she is seeking.
She's asking for second, third opinions from the directors of every department.
It's
The
difficult.
hospitals have a right to run, according to their own protocols. So what do you do this here? It's not enough to mediate. What legal solution do you propose?
Well, there may not be a legal remedy.
So they should
in
just
terms of-
remove her forcefully from the place?
I think all of us have agreed that that's an unpalatable situation. The hospital has expressed concern about liability. I think they probably do have the ability to say, you can't stay here, you don't need hospital level of care. But before you get to that point, I think there are other steps that could have been taken to address the admittedly very difficult, very untenable situation.
And what
but
kind of steps again are those? I know you said they're in the brief, but.
there could have been mediation. The judge made specific findings that, and I don't deny that this was a very difficult
Went through a couple
client.
lawyers too, though, didn't she? I mean, she fired her lawyer once or twice?
The first lawyer withdrew, yeah.
But the judgment says the hospital request to transfer D.C. to a skilled level nursing facility is allowed. What does that mean?
I don't know, because our position is that once the judge found her not to be an incapacitated person in the context of a guardianship proceeding, there is no further authority. So that
The
was a
judge just-
request.
The judgment allowed their request to transfer. So what do we do with that?
Again, that was within the context of a petition for guardianship.
I understand, which was denied, I understand. But isn't that sort of the core issue, is the judge says, yes, she should be transferred, and the hospital appropriately wishes to transfer her, and I'm going to
Right.
allow their request.
Right.
But I don't think she meets the standard for a guardianship.
I think that's a nullity. I think that the other laws that would apply to their ability to get some kind of declaratory judgment or, an order to vacate the premises, whatever it happens to be, against a competent person who can no longer be there, they may have those legal avenues available to them. But once she was found not to be an incapacitated person, a judge in the context of a guardianship proceeding doesn't have the ability to intrude on the autonomy of a person who's
So
been
they
found
should sue her?
not to be incapacitated.
They should sue her as a trespasser? I'm just...
I know, it is admittedly a very difficult situation. Our view would be, and I think the question before the court is, did the court properly apply the definition of incapacitated person, which we think they did.
That part you said yes, but it also sounds as if you're saying the judge erred by allowing the hospital's request to transfer. That if this had
Yes.
not been moot, you would be saying that the allowance of that motion should be vacated.
Yes, in the
Because
context
there's
of a
no
guardianship
authority.
proceeding, no authority in the context of a guardianship proceeding to order a person who's been found not to be incapacitated, to issue that kind of order.
You both agree on that?
Yes.
Okay, so I'm trying to sort out how to make this a better world.
Appreciate that, Your Honor.
Do you agree, before you answer the Chief Justice's question, do you agree with your brother that this isn't happening a lot?
In terms of a judge ordering somebody
Right.
to be transferred to a nursing home
Without the appropriate findings?
I have not seen it before this case.
I turn you back to the Chief.
Okay, so your brother says there should be this thing called a limited guardianship, which I guess exists, and that there can be a finding that you are incapable of essentially thoughtfully determining whether or not you should be transferred to a nursing facility or to a nursing home, and that a court can order a limited guardianship for that limited purpose. Do you agree with that?
To the extent that there's a finding of incapacity that meets the statutory definition, it's clear from both the MUPC and prior case law that a person can be found competent for some purposes, not competent for other purposes, and that a limited guardianship can be imposed or tailored to address that. But under the MUPC, the condition precedent to any type of guardianship, whether limited or plenary, is that the person is an incapacitated person. What areas they have capacity and they lack capacity, can be the subject of a limited guardianship. Probably the one that's most common, that we see most commonly,
Financial,
is, well, that's a conservatorship. That's a whole other story under the MUPC. But we see somebody, for instance, who may have a mental illness, who has the ability to make decisions in every other area except with respect to antipsychotic medication. So the judge may find the person to be incapacitated for that purpose, impose a limited guardianship, and that is the only decision-making area that is.
In this case, you're saying a limited guardianship would not have been an option because she had already been found.
Not to be an incapacitated person, exactly, Your Honor.
Can't do that.
Exactly. Not under these facts. And in terms of the judge's findings, the judge heard testimony from 3 doctors for the hospital and testimony from D.C. herself, who was a very active participant. So similar to the case of the guardianship versus Jackson, it wasn't as if the judge wasn't considering all of the testimony and applying the definition of the MUPC very carefully to the facts that were
So
before
we're
him.
still left with the person who is perfectly able to rationalize and decides, no, yes, I'd like to stay here. And you're saying there is no answer.
Well, I don't think that that's what the judge found, that she was
No.
perfectly happy to stay here. I mean, just to bring it back to the facts of this case, because the judge did find, yes, she wants hip replacement surgery. No, she doesn't want to stay in the hospital forever. She wants to get back to her apartment.
But she won't
wanted a
take
second
any
opinion.
coagulant drugs that's necessary for hip surgery, and she won't, I mean,
But again, Your Honor, some of these things are susceptible to a clinical approach or a mediation approach. There was no treatment that was offered to the extent that the hospital is asserting that she has a particular mental disability and that that's interfering with her being able to get the treatment that she needs or make good decisions from their standpoint. There were no clinical or therapeutic
was being
approaches that were
difficult.
taken. She was being difficult, absolutely.
So what do you do with somebody who's being difficult? I guess, putting
There
aside.
may not be a legal remedy if the person is difficult and demanding, as this court found, but doesn't meet the statutory definition of incapacitated person, then there are other approaches that are non-legal remedies that should be tried first in terms of a clinical approach, in terms of
I mean, they
mediation.
sent one psychiatrist after another to try to talk to her and reason with her. It's not as if they just said, we're putting you into a guardianship. They provided a bunch of they even provided second consults, right, for her? I just, it's not as if they didn't explore options. So when you've got someone who can't make any kind of sensible health care decisions, your view is there's no way a limited guardianship, you've got to have a mental disability that rises to this psychotic level, antipsychotic level of drugs. I'm trying to understand, we've got someone who's more than just difficult. She's difficult and borderline making very dangerous health decisions for herself and imposing difficult problems for the hospital. That's never going to get you into this limited guardianship you're telling me, right?
Your Honor, I'm glad you posed that question because I think it was a little bit unclear from the hospital's brief. Under our case law, and it's not inconsistent with the MUPC, the end result, whether somebody's decision is wise or unwise or reasonable or rational in the eyes of the medical providers, is not the test of capacity. The test of capacity
If
is
they're
the
willing to
process.
leave, it's fine. It's when they can't get them out of the hospital that it becomes everyone's problem, or we wouldn't be here, right? If she just didn't want to make good decisions and they could say, well, time to leave, we wouldn't have any problem here. They would say, time to go home, right? It's that she's unable to be moved that makes this so hard.
Maybe this is such a difficult situation, and I'm still interested in understanding whether it's a problem out there. But maybe to make it a better world, there needs to be legislation to address this issue. Because, if this happens with any frequency, there's not going to be any money for early childhood education. There's not going to be any money for the CPCS budget. I mean, sometimes there's, if it's a big enough problem, you find a solution. But neither of you, as much as we try, and I think you're just being careful advocates and relying on the law that you have, and have suggested that there is a legal solution within the MUPC to this particular problem. And I appreciate we keep on asking you, but your answer is grounded in the statute and the law, and that's why it seems to me you're not able to give us a silver bullet answer.
Right, I think that if you were asking me to go beyond the law and the case law, first, do I think this is a common problem? In my experience, no. I also think that there are other resources aside from a nursing home that may have been palatable to this individual that do amount to a safe discharge in terms of personal care attendance. If she was in the community, she may have had access to the hospitals and the doctors that she was seeking access to in terms of having the hip replacement surgery. So there may not be a legal solution. That doesn't mean that there wasn't another practical solution and that this court is required, as somebody said before, to sort of contort the law to fit really difficult facts for a problem that I don't think is all that common.
Okay, thank you.
Okay, thank you.